Development and Human Rights. The chair for this session is Professor Dr. Mohan Kumar, Professor and Vice Dean, Jindal School of International Affairs. Dr. Kumar has had an outstanding career in the Indian Foreign Service lasting 36 years, culminating in his position as the Ambassador of India to France. He comes with extensive experience in the area of international trade. Dr. Kumar has been India's lead negotiator at the GATT and the WTO in crucial areas such as intellectual property rights, services, dispute settlement, rules and technical barriers to trade. He has also been a part of India's delegation at the WTO ministerial conferences held in Marrakesh, Seattle, and Doha. Over to Professor Kumar.
Thank you very much, Professor Stephen Marks. And I think it's only appropriate that we cover this important subject as part of a day-long conference conducted by Harvard and OP Jindal. I'm not getting into the business of introducing everybody, although Alia was, I think, fulsome in her praise of me. I could be equally fulsome in my praise of introducing my colleagues. I will take it as read, because we need to really jump into the subject. I'm going to spend 5 to 8 minutes introducing what I believe should be the outline of this discussion, but I would like to tell the participants that they have full freedom to do whatever they want to do, and maybe give about 10 minutes each, and I will go by the order that is listed. So we will begin with you, Anuradha, then James, you will speak for 10 minutes, and then Pallavi, you can speak in French and English, both. Okay, and Prabhash Ranjan. So I think this way we will have at least half an hour to 45 minutes for discussions, which is, I think, the more interesting part of it, frankly. So I just want to begin by saying the link between trade and sustainable development is straightforward, has been explored in the WTO, and I will confine myself only to it because I know the subject. That continues to be a part of the Doha negotiating agenda. It is another matter that the Doha round is dead and the WTO is on the verge of extinction, but that's different. I mean, the negotiation agenda is still there, and there is a bulk of literature that you will find on trade and sustainable development, which is fascinating and important. The less direct, the less obvious thing is trade and human rights, because by definition, trade diplomats such as me, and especially since I come from a developing country like India, which values sovereignty, policy space, the rest of it, and you heard from Professor Jayati Ghosh, we are completely averse to the idea of even accepting a link between trade and human rights. We just do not believe that there is any scope, that any role for trade. Because the moment you accept a role for trade in human rights, you will have to contemplate sanctions. And that is anathema to many of us who come from this school of diplomacy, developing countries and the rest of it. The speakers obviously are free to disagree with this, and that's how we will have a debate. So I want to begin by saying it is not even clear to me that if you follow the path of trade liberalization and you achieve reasonable prosperity, human rights is going to be better. And I'm no longer a diplomat, so I have no problem naming countries, Stephen. I can very easily name Saudi Arabia and China as examples of that, frankly. So it is not even clear to me what role trade can really play. And I'm trying to provoke speakers and students here. I would argue that this is really very, very abstruse, and it's not at all obvious to me what role trade can play in human rights. However, I will now spend 5 minutes on what the subject, that is trade and sustainable development. That is much more straightforward. As early as 1992, just before the WTO came into being, I was involved heavily with the negotiation of a ministerial declaration which appeared in Marrakesh for the first time, outlining this declaration on trade and environment. We were very nervous because even at that time we had just finished a case in the WTO called the shrimps turtle dispute. I don't know how many of you know this dispute. It's a very fascinating dispute. Very simply,
the United States of America, as is its wont, and Stephen will forgive me when I say that, they banned shrimps from a group of countries, India, Thailand, because while catching shrimps, we killed turtles, incidentally. And that was considered objectionable to the US Environmental Protection Agency. I used to joke to my American negotiator that obviously you value the life of turtles much more than the life of poor fishermen in Orissa, because that's how it turned out. But then they lost that case, and it was against the backdrop of cases being lost in the GATT, as it was known then. Because in GATT there was a clear jurisprudence that trade cannot be used extraterritorially for protection of environment. You can, if United States wants, it can use trade to protect its environment. We have no problem. If they say you're catching shrimp in the United States, you make sure you don't kill turtles. But they have no right to tell India, Thailand, or anybody else that turtles have, that was law as it existed at the time of GATT. Since then, I'm happy to say WTO law has evolved. So there is Article 20, which is the exception to GATT, and which clearly says for protection of plant, animal life, and human life, you can actually take exceptions from what is considered the bedrock of international trade, which is Article 1 MFN, Most Favored Nation Clause, basically an article that deals with non-discrimination, right? However, Article 20 in the GATT places certain restrictions, and there are some criteria that you need to follow. First, when you use trade for promoting sustainable development, you should not do it through arbitrary or unjustifiable discrimination. So the rule of non-discrimination is important. Secondly, you cannot use it as a disguised restriction on trade itself. It should be a measure that promotes sustainable development. And finally, and perhaps most importantly, there is a necessity test and a proportionality test. You use trade measures for promoting sustainable development only when everything else has failed. You should be able to try other means of cooperation, other means of incentives before you move to this stage of trade. Trade will be used to promote sustainable development only when it is necessary. And then there is a proportionality test, which is that you use only trade restrictions which are necessary to achieve the objective, not more trade restrictive than necessary. That is, you don't go around, for example, you don't go around saying you ban a product. You can't ban a shirt coming from India into the United States because the textile factory making the shirt in India does not follow environmental standards or does not treat the effluents, and textile is considered a dirty industry for very valid reasons. But if you do not have the factory treating the effluents properly, you cannot impose an additional tax on the shirt coming from India. That's the WTO rule, and that's why we talk of bound tariffs and MFN. So this is really the background against which I'm going to now hand it over to speakers to continue as they like. But I do want to repeat the two propositions I make. Trade can be used to promote sustainable development. You cannot, however, use trade without certain restrictions or certain, shall we say, parameters, and those parameters will be non-discrimination, not more trade restrictive than necessary, etc. The link between trade and human rights is less obvious to me. I would not go down that route because what you have in the case of human rights violations is then you are talking about responsibility to protect and the rest of it. Serious cases of human rights violation, I would not think as a trade negotiator in the past that trade has such an important role to play. Indeed, there are actually cases of countries which are much more prosperous than India and which do not really have the human rights standards that India has. So that should be enough to kind of tell you that trade and human rights, you are entering us, or at least you're going down a slippery slope. Trade and sustainable development, by all means, with just one last comment, which is, I have always felt that multilateral agreements to promote sustainable development are way better than unilateral imposition or unilateral trade measures. Paris Agreement is a good one. There are some countries or one country, one important country which is withdrawn. I'm hoping that that can be reversed in the future. But otherwise, we have gone from Kyoto Protocol, which was completely torpedoed by the developed countries and they said they can't accept it, so that's gone. What we have by way of a Paris Climate Change Accord is a new thing where we have allowed each country to indicate what their national objectives are. And it's a pretty decent effort. The IPCC report says that's not good enough, and I'm willing to accept that. You need to do more. But I think it's a good model to follow, the Paris Accord, where you do not use trade sanctions, but you really appealing to countries to do their best. The last point I would also make, and this is really the last point, forgive me, is that in the case of trade and sustainable development, I believe there is a link that you can make, or a proposition that you can make, that as countries become more prosperous, their own populations will demand cleaner air and better environmental standards. We've seen that in China, because that's a good example, and we certainly see it in Delhi. The climate change accords in Paris was a turning point for India. We effectively, and I'm no longer a diplomat now, so I can say this frankly, we effectively buried common but differentiated responsibilities in Paris. Big deal for India. We've been harping on common but differentiated responsibilities for 20 years. And to bury this in Paris and go along with the rest, huge step. Most people think of India as very negative in multilateral negotiations. I would always point them to Paris. Paris wouldn't have happened without India, frankly. I know there was a deal between US and China. I sincerely believe that India, from trying to be a part of the problem, has actually tried to be a part of the solution by accepting the Paris International Accord on Sustainable Development. So with those few rambling remarks, I had no script, I will now turn over the floor to Anuradha. Your reputation precedes you, and they have read your CV, so you can jump in straight. Thank you.
Thank you, Dr. On a few crucial points, points of agreement and disagreement with,
Sure.
with what you've just highlighted. On the whole, yes, I think a multilateral solution to environment, to economic, social problems, and to trade is something which is something which has to be promoted, which is certainly preferable to any kind of other mechanism. And also the point that very crucial point that you made, that trade perhaps is not the best instrument for promoting environment and labor standards or even sustainable development, because trade comes with a mercantilist approach which is premised on the instrument of sanctions for implementation and may not really be the best way to move forward. Let me just pause here a little bit to also wind back to what you also highlighted, that the Marrakesh Agreement establishing the WTO recognizes the principle of sustainable development, in fact, in the very opening paragraph of the WTO agreement itself. And very interestingly, when it talks about sustainable development, it refers to it, it's a complex and one of the most nuanced worded paragraphs where it highlights that members that are entering into the WTO recognize that the optimal use of the world's resources in accordance with the objective of sustainable development, seeking both to protect and preserve the environment, to enhance the means of doing so in a manner consistent with their respective needs and concerns at different levels of economic development. And at an earlier part, it also refers to the fact that employment and the labor market is something which is also a fundamental component of the overall synergies that it envisages. The point that I want to highlight here is the fact that clearly the first paragraph, when it recognizes sustainable development, implicit in it is the recognition that there is really no one-size-fits-all approach with regard to whether it is economic policies or environmentally sustainable policies. Differences are something which are inherent because different countries will be at different levels of economic growth. Let's wind down a few years later, I guess 2 years after the Marrakesh Agreement, at the Singapore Ministerial Conference, when a number of developed countries were trying to push in labor as a component of WTO and pushing negotiations on this aspect. Most of the countries at the WTO prevailed, and the Singapore Declaration actually recognized that because of the inherent advantages that labor markets actually provide countries to gain a comparative advantage in trade, a provision of the Singapore Declaration clearly recognizes that trade policies will not be used in a manner to undermine the comparative advantage that countries may have because of different wage levels. Now, having said all of that, clearly what we really have is a framework where I fundamentally believe that while social and environmental goals are crucial elements, and in fact, we often think of sustainable development as comprising of 3 pillars: the economic, the social, and the environmental. And all of them have to go in a synergistic manner to achieve sustainable development. But trade cannot be the instrument for achieving it because it is fundamentally flawed. Now, let's again just to very, very quickly highlight how it's not as if we do not have multilateral instruments on labor. It's not as if we do not have multilateral instruments on environment. We do have it under the aegis of the UN, which to a large extent has been getting compromised and diluted despite the Paris Agreement. But just to very quickly highlight, how does ILO do it, the International Labour Organization, which is the multilateral organization that is responsible for labor-related standards. I don't know how many of you are aware that the ILO has, of course, hundreds of conventions and recommendations. There are something called 8 fundamental or core conventions. Out of the 8 fundamental conventions, how many is India party to? We have ratified 4 of them. How much has US ratified? They've ratified exactly 2 out of 8. The country which is today actually going ahead with the agenda for invoking and using labor and environmental standards as part of trade agreements is the country which has actually not ratified 6 of the 8 fundamental code conventions as far as the multilateral framework on labor is concerned. Dr. Mohan Kumar has already mentioned that environment is also an area where they are laggards. They had withdrawn from the Paris Agreement, but prior to that, in 1997, when the Kyoto Protocol to the UN Framework Convention on Climate Change was entered into, US was not a party to that either. They have been outliers as far as multilateral action in the field of environment and labor is concerned. But they've been pushing this as part of the trade agenda, which is fundamentally flawed in handling many of these issues. Winding back very quickly again to the shrimp turtle case, it's a crucial decision, a landmark decision for India. But that win that we had, the victory that we had was short-lived. And primarily because the WTO appellate body had left the room open for the extraterritorial application of an environmental standard by recognizing that turtles fundamentally are migratory species. They do go to high seas, and therefore there is a common concern in their preservation. Completely logical. But what was the solution that the trade agreement could enforce? They said that US had an agreement with a few Central American countries for preservation of turtles. US is required to go negotiate with India, Thailand, Malaysia, which were parties to the dispute. US goes back and says that they have made honest, good faith attempts to negotiate, but they could not achieve an agreement. Wind over a few years later, it goes to what we call the Wto Compliance Panel, and the Wto Compliance Panel says that the US has made an attempt to negotiate an agreement for protection of sea turtles with these countries, but they have failed to arrive at an agreement. We only wanted them to make an attempt but not have to agree, and hence US can continue with its policies as far as the ban on the import of shrimps from these countries were concerned. So ultimately the way it really worked out was that the WTO in effect was ineffective in addressing this. Who stepped in? At that same point of time, it was UNEP, the UN Environment Program, which came with a series of programs for actually giving turtle excluding devices or TEDs to Indian shrimp farmers to use in order to protect the sea turtles. So WTO has absolutely no mechanism for having facilitated any of that. This is as far as I wanted to reflect on the international part of it is concerned. I'll just take 3 more minutes to reflect on sustainable development, why it is important as a goal in itself, and the fact that, what I find also, a complete siloed and isolationist approach, in fact, a domestic policy is concerned, is that Indian law, Indian regulatory frameworks do not imbibe sustainable development as a fundamental component of our own policy making. We actually see trade as separate and labor and environment as separate. There's no synergy, or there is no holistic manner in which these issues can be addressed. And I'll just take one example of a headline that appeared a couple of days back on the Ministry of Home Affairs coming up with a policy on liberalizing visas for medical tourists. Just to give an example, on the face of it, one would wonder why would I have a problem with that? It's actually a fantastic move. It's a great move. India has advantage as far as services exports are concerned. Why is it that when foreign tourists come to India for medical assistance, why does it qualify as service exports? The fact is that any kind of foreign exchange that is earned in India, which qualifies as a foreigner availing of services of an Indian professional, will qualify as an export of services, which has significant potential. We have the brains, we have the infrastructure, we have the medical facilities to actually make this sector grow, and it's a highly important aspect of our overall growth scenario. To just give you an idea of statistics, the health services exports from India as of 2015-16, and specifically for medical tourism, was estimated as $620 million. A number of hospitals, especially in Gurgaon, I've heard Artemis advertise that 80% of their revenues actually comes from foreign medical tourists, which is something which they believe is contributing to the overall export share of India. There have been estimates by the IBEF that India's share in medical tourism will actually go up to $280 billion by 2020. It's like an exponential amount of growth, and the MHA step is one little step in that regard. The huge cost advantages to having services being availed of in India. But are we doing it in a manner that accounts for sustainability? We are in a state where medical services for Indians itself is something which is getting compromised. Of course, there have been policies like Modi Care. How it gets implemented is yet to be seen, and there are a variety of other government initiatives. But does it really merge into overall policy making? And let me just give you the example of 2 other countries where medical tourism has been something which has been attempted, and in completely different ways. One of the examples is that of Cuba, and I was myself surprised to learn that Cuba has been one of the biggest countries in terms of its role in providing healthcare services is concerned since the 80s itself. And the way Cuba does it is through a government organization called Cerumed that enters into bilateral agreements with several countries. Cuban health professionals actually have arrangements with close to 77 countries. And Cuba's earnings from medical tourism exports is considered to be in the range of $8 to $10 billion. Okay. And what Cuba does, because of the functioning of the Cerumed that they have, is that a huge amount of the profits or revenue shared from these earnings is pumped back into the public healthcare system of Cuba itself, which is supposed to, again, lead to a sustainability factor in terms of how it is actually implementing public healthcare services for its own citizens. There have been, I'm not saying that it's all a rosy picture, there have been a few criticisms about what really happens, but overall, it is certainly better than what most other countries do. To contrast with this is the experience of Thailand. Thailand's export earnings from what they call health and wellness tourism is again in the same range, $8 to $9 billion. And this is something that they have been promoting as part of their tourism industry, as part of their medical and wellness tourism sector, and attracting a lot of foreigners to come and avail of these services. But studies have also shown that a consequence of that, because of lack of complete backward linkages of how this links with Thailand's own healthcare system has almost led to a reverse discrimination against Thai citizens. So there are private hospitals in Thailand who will actually prefer foreign medical tours because they come with bigger revenues, they have deeper pockets, they don't have to be subsidized as far as healthcare systems are concerned. There actually been studies which show that Thai hospitals have been turning away domestic patients. The question really is, at the crossroad that we are in, as far as healthcare tourism is concerned, it's crucial. It will have give a great fillip to what we call mode 2 of our services exports, which have so far been terribly neglected. But in terms of building that whole concept as part of a sustainable manner in which to deliver it is something which has yet to be achieved. With just that little thought, I'll conclude and leave for the next speakers.
Thank you very much, Anuradha. That was useful. You are right. I did make, one error of omission, if you like. Labor has always been part of WTO law. I mean, as early as the Havana Charter, for those of you who know 1947-48, take a look at it because it's becoming very important again. The Havana Charter, which was aborted by the United States because the United States did not want International Trade Organization to come into being, so then we had to negotiate again and get the GATT in order. And GATT was never an organization because the United States was viscerally opposed to supranational authorities which will take away its sovereignty. We always had prison labor as part of WTO, of GATT. There was always an issue with labor. And that is why there was always a push to include labor standards. For those of you who are interested in the development of this law of trade and on the one hand and sustainable development and labor on the other, take a look at the agreement which has just been signed, which replaces NAFTA, which is called USMCA. Exactly, I think it's called MCA. The important thing is they no longer call it a free trade agreement, it's just called an agreement. And it says United States, Canada, Mexico agreement. You have two provisions which are worthy of note for those of you who are interested in the subject. The previous NAFTA agreement had the environment only as a side letter. It was not an integral part of the agreement and therefore was not subject to dispute settlement in that sense. Now it's a part of the main agreement. And more importantly, the labor standards now that you see in this United States-Mexico agreement is very important. For example, some proportion of the product, especially when it comes to automobiles, will have to be done by labor with a minimum wage of $16 per hour. It straight away rules out Mexico. Nobody working in an auto factory in Mexico will make $16 an hour. So I'm not even sure about Canada actually, but anyway, it definitely rules out Mexico. So this is interesting. It's now part of the main agreement. As you know, those of you who follow trade will know that all these things will start first in a free trade agreement and then slowly find its way to the WTO. That's what happens. That's the kind of migration that you see. But thank you very much, Anuradha. The next speaker is James Pura. If you care to look at his CV, you will know that he is supremely qualified to speak on this issue. James, you have the floor.
Thank you. And I should also say that, my own understanding of human rights was very skewed to an extent until I got an opportunity to work on an article which Petersman had actually written in this book. And I had a chance to edit this particular article, and it focused on the methodological issues in international economic law with respect to democratic principles. So, yeah. So what Petersman is trying to argue, so let me tell you that I'm heavily indebted to him for my own presentation here. So what he argues in this article is that human rights and market freedoms are essentially the same thing. So whenever we have a debate on this issue, so we always pit something against another. So when we say that free trade is actually, free trade is only promoting trade, which is basically services, goods or capital, then we have on the other side, which is basically human rights. So human rights are being traded away for something which is trade, capital and services. And some people argue that that is actually a wrong debate. So when we think about trade for that matter, human rights should be embedded as part of it. where human rights should be an integral element to trade. So that is what Petersman has been trying to argue in his article. And if you look at various kinds of human rights, economic liberty is the most important thing. And we know that in the field of international trade or investment, obviously the individuals are involved, but most of the firms that trade or most of the enterprises that invest in other countries are actually corporate bodies. Do corporate bodies have human rights? I do not know. But whenever they make business in a particular country or in an area, sometimes it may have certain kind of an effect on the rights of other people. So that is why I think Petersman argues in his article, and I mean, I should also say that he is one of the really topmost scholars in this area who has been writing on this topic for the last 15-20 years. So some people can take issue with his argument. Some people like Philip Alston has said that there is nothing called human rights in trade agreement. That is actually a sham to an extent, right? But he says that, okay, you can't treat these two things as separate silos. So whenever you think human rights, you can't actually have an argument one against the other, but it has to be part of the same thing. So now let me try to understand, when we really look at trade and human rights, we often refer to a very important piece of document called the VCLT. VCLT is not actually part of the International Trade Agreement. It is not part of the WTO agreement. But if you look at Article 3.2 of the Dispute Settlement Understanding, they say that the WTO agreements will have to be interpreted according to customary principles of international. And if you look at any WTO case for that matter, maybe you will find some 20, 30 or 40 references to VCLT. So VCLT to an extent is actually part of the international economic law system. And when we read the VCLT, there are two important provisions within the preamble. The first one says...
Sorry, James.
Yeah.
VCLT is Vienna Convention of the Law of Treaties. I know the law school students would know this, but there are others, so
right.
Thank you.
Absolutely. So what it says is the disputes concerning treaties, like other international disputes, should be settled by peaceful means and conformity with the principles of justice and international law. So the point here is that if you look at the WTO treaty for that matter, there is not even a reference to the term justice. So you can look at the preamble of the Marrakesh Agreement, you can look at the WTO treaty, the term justice is not mentioned anywhere. And if you look at the latter part of it again, recording the determination of the peoples of the United Nations to establish conditions under which justice and respect for the obligations arising from the treaties can be maintained. So the term justice has been repeated twice in the preamble of the Vienna Convention. So now when we think about trade, I think trade is only a very small part of the international economic law domain. So we have got international trade law, the WTO law, the GATT law, now the NAFTA or maybe the replacement of that thing. We have got mega regional agreements, TPP, CPP, TPP, then you have so many other agreements at the same time. So we can classify them as preferential trade agreements or mega regional agreements. Then we have also international economic institutions like the World Bank, the IMF, UNCTAD, then ADB, G20. There are so many other organizations and OECD for that matter. So if you look at the issue of export credit in the subsidies agreement, there is actually a reference to the OECD official arrangement on export credit. So there are so many agencies which may have some kind of an impact on the way the WTO system functions. So now let me think about the arguments which are actually in this area. So the first argument is that free trade itself is a human right. And what is actually free trade? Open borders, open markets, freedom of people to move across the countries, freedom of competition. Like the European Union typifies what is actually the ultimate thing of free trade. So you have got complete economic integration. So economic integration is actually a very important concept of Peterson's argument. The second is that when you actually open up the borders, you also get access to the markets, you get cheaper inputs, the labor will get an access to work in other countries. So maybe that could be one of the issues the Brexit happened, because the labor from other countries came to Great Britain, and that might have resulted in some kind of a backlash. And when we look at greater access to products, we can also look at other schemes like the GSP scheme. It is actually it is a voluntary, it is a gratuitous scheme. So it is a kind of a donation given by the rich countries to the poor countries. But when we really look at the effect of all these things, right? When you really look at the larger picture, a free trade agreement is basically enhancing trade. And we know that trade is an engine of growth. So once you have got free trade, you are going to lift up millions of people out of poverty. So there is a direct impact between free trade and poverty alleviation to an extent. Then the second important concept is actually the concept of public good, res publica. So Petersman again calls it something called an aggregate public good. So when you think about free trade, there are so many other things. Free trade enhances transparency, it enhances the democratic process, it enhances consensus building. So there are so many other things which are actually part of the WTO deal. So even China is now a member of the WTO, but when China is becoming part of the WTO, they are also to an extent acceding to the democratic principles. May not be internally, but at least externally. In the sense, so that is why there are so many, you can say, spillover effects when a country joins the international trading system. So according to one set of scholars, even the free trade agreement or being part of the free trade agreement itself is actually a public good. And then, so this is actually one of the interesting arguments. But when we really look at the debates, Professor Mohan Kumar and Anirudh also mentioned about the kind of disputes in the WTO. So I'm going to take a snapshot of some of the disputes. So you have got the shrimp turtle case where the United States came up with an import ban on shrimp products, basically because the way the shrimp was harvested was not according to the United States practice. The Brazil tire case, so they had a problem with the accumulation of old and used tires, so they want to ban the product, saying that if you have got an accumulation of tire, then Brazil is a tropical country, the rainwater will get collected in the used tire, the mosquitoes will breed, then you have got dengue and other kind of diseases. But anyway, if you look at all these kind of measures, they are actually taken for a public cause. Or you can say there is a greater common good in taking a trade measure. But the point here is that if you look at all these kind of disputes, easy asbestos, we know that it is a product with a carcinogenic property. If you are exposed to the product over a long period of time, you can get cancer. And if you look at the plain packaging again, cigarette is harmful to life. But if you come up with certain kind of a plain packaging requirements, it can affect the trademark right of somebody. So again, the point is that in all these issues, there is some kind of a debate of free trade versus something else. And that is why the WTO panels and the appellate body have been doing all this kind of balancing exercise. So if you look at one case, the Korea beef case, they said, you had to assume that this is actually a spectrum. On the one side of the spectrum, you have got to respect the autonomy of a state to preserve the vital societal interest. So the appellate body said that if an action is actually close to the pole of indispensability, that means if you do not have any other measure which might or could have met that particular objective, then okay, your policy will be given some kind of a green signal. But the truth is that when it comes to WTO, we have to use invoke the proverbial camel's example. It is difficult for a camel to pass through the eye of a needle than for a rich man to enter the kingdom of God. No, not even two cases have actually gone through the hoops of Article 20. Only two cases. One is the shrimp turtle case, and the second is the asbestos case. So it is very difficult to invoke these kind of provisions in the WTO. Sales again, absolutely. So now this is actually, I looked at the Guardian newspaper. So this is after the plain tobacco case, and they said a resounding victory for human rights and too bad for trade. Too bad for trade. So this actually sums up the kind of notions people have in mind. That whenever countries negotiate free trade agreements, they also come up with some kind of public moral exceptions. But it is always difficult to balance these two things, to embed the human rights elements, the economic liberties aspect into the free trade issues. I have a couple of more slides. So then the question is that if trade and human rights are actually associated concepts, or I would say two sides of the same coin, then why oppose social clauses, right? So we have got this kind of an issue from the tuna dolphin case, and what the panel said in the tuna dolphin case is actually very, very important thing. Treat tuna as a product. Do not treat tuna as a dolphin-friendly tuna or a dolphin-unfriendly tuna. So you have to treat the product as a product, and they said that the PPMs are actually out of the window in WTO dispute settlement, especially in Article 3.4 of the GATT. But let me tell you, when we really look at all these free trade agreements with the labor clauses or environmental clauses, these are not actually maintained for any love or labor or love of human rights. And I would actually say it is a kind of a homo economicus argument. every business enterprise or entrepreneur is actually acting like a rational economic actor. So if Bangladesh has got a factory, and if the government does not enforce the labor requirements strictly in that particular country, then Bangladesh is implicitly giving a subsidy to that industry. And that subsidy will basically tilt the level playing field. So most of the countries are again looking at human rights issues or social clauses through the lens of comparative advantage, which is a wrong notion. So that is why we have got all these kind of unwarranted concerns coming in. The one thing is extraterritoriality. The major concern is that you can't transport your own regulations and other things across the border because you care about all these things. Admittedly, the WTO appellate body has said in so many cases that there is a certain amount of cosmopolitanism. There is a certain kind of acceptance that these values are universal values. So if there is a present labor in another country, if there is shortage of clean energy in a particular country, then you have to actually treat them as a global public good, and the trade measures should not stand in the way of a country following these kind of measures. So these are very important concerns, and I think the debate will go on for a long period of time. So let me actually sum up with this particular thing. One more important thing which I wanted to mention here. You can actually make certain changes. If you look at the WTO legal system, the WTO legal system is heavily dependent upon the WTO covered agreements. So whenever you look at the WTO agreement, they say these are actually rights and obligations flowing from the covered agreements. And Article 3.2 of the DSU again says that the panel of the appellate body cannot add to or diminish the rights of the parties here. But again, they make a cursory reference to the customary rules of international law. But now contrast this particular thing. If you want to put the sources of WTO in one particular column and the sources of law under the international law, which refers to Article 38 of the ICJ statute, the sources are very different. If you look at the ICJ statute, it refers to international conventions, international customs as a general practice accepted by law. You actually find a reference to civilized nations. I'm not saying that the WTO members are uncivilized. Then it also refers to the generally qualified publicists. So the source of law under general public international law is actually much bigger. But when it comes to WTO treaty, it is only the covered agreement. But at the same time, there is actually some kind of a reference to the customary international law. And that is why in some of the important cases, including the GM food case, I think the genetically modified case, the panel said that you have to actually look at Article 31.3 of the Vienna Convention that talks about systemic integration. Again, in the Peru additional duty case, that issue was basically introduced. So you should not actually try to interpret the WTO in clinical isolation from public international law. So WTO law is not actually a closed system. It is enmeshed with other sources of public international law. So my last slide is this. The last slide is integration. So WTO should not be sitting in a silo, it should be integrated. Then the second most important thing is, so when the shrimp turtle ruling came out, many people said, there is a unidimensional acceptance of the telos of trade. So what is the telos of trade? I think free trade should be enhanced. So the WTO ruling, the panel ruling in the shrimp turtle case, single-handedly promoted free trade, but it did not actually accept environmental concerns. But the one good thing, which is actually some kind of an addition to what Anurag mentioned, the shrimp turtle case we know that Malaysia again lost the case at the second stage of the 21.5 case, but at least the appellate body accepted the possibility of a measure passing through all the hoops. And again in the asbestos case, the panel actually did that. And even in the seals case, the appellate body said that technically a measure can have. But in this particular case, the country haven't actually got the bona fide action. So they haven't. So this is not really calibrated to achieving that particular objective. Therefore, this will fall. So the last point which I want to mention is that when appellate body judges, they are not actually trade diplomats. Of course, trade diplomats are very smart people, but you have to also bring in the elements of, you have to think socially, you have to think morally, and you have to think beyond trade. So that's the kind of suggestion I have.
Thank you, James. I think your speech met every expectation of mine. This is what I expected from you. I think it's for somebody like me who's done trade policy for 20 odd years, this is completely different. It challenges the traditional basis on which Indian negotiators perform in the WTO, and that's fantastic for a forum like this. So I'd love students to react to this. For him to say that trade and human rights are two sides of the same coin is absolutely nothing short of revolutionary in terms of thinking for a trade diplomat. It is. And because you can easily contemplate a situation today where Europe actually accuses United States of social dumping. Because Europe can legitimately claim that United States doesn't follow high environmental standards, not just because you inject hormone into a beef, and that's a whole different ballgame, but even just standards of air and burning of coal, etc. So you can have very interesting scenarios. Pallavi, vous avez la parole 10 minutes maximum. Hein? Merci.
Definitions, human rights, sustainable development, and then the SDGs. But I'll come to the GATT and WTO very quickly. So we see that there are certain similarities and differences in their preambles, and the differences basically focus on sustainable development and environment, words which have been used in the preamble of the WTO. So obviously we can say that the WTO is very concerned about these issues because these were absent in the preamble of the GATT. But note that 50 years already passed between the enactment of the two laws. So, and of course in the WTO you have all these bodies and instruments that further protect sustainable development. And these committees, for example, work quite closely. So if that is the case with the WTO, which seems to be very concerned about protection of sustainable development and to a certain extent human rights, let us see what mechanism it uses. The mechanism it uses to protect them is by way of exceptions. So a number of my colleagues have already talked of Article 20. I'll also talk of it, but I'll also talk of other laws. So yes, WTO law uses exceptions, and the use of the exceptions is closely monitored by the members, and also the dispute settlement mechanism if a dispute arises. So as they are exceptions, of course, they are closely monitored. Now, these exceptions include Article 20, which my colleagues mentioned, and which was the only exception at the time of the GATT. But in the WTO, since it wanted to expand on this, we have TBT and SPS agreements, which basically allowed regulated restrictions on trade. But again, they follow the GATT jurisprudence that the restriction should be necessary, that is least trade restrictive, and they also ask for scientific evidence. So ultimately, they are very concerned about the restrictions that we impose on trade, that these restrictions should be the least trade restrictive and should be supported by scientific evidence. So in that sense, the jurisprudence or the rationale of GATT Article 20 is quite alive in these agreements as well. Now, let us go to issues, now this first issue that I want to look at is that of food security, and of course it has created a lot of controversy. And basically, why it has created controversy is that, developing country members use these public stockholding programs, which involve support to farmers, and this distorts trade, and this obviously bothers the WTO law because the WTO law is about promoting free trade, so naturally it will bother them. But then on the other hand, we also have subsidies which are granted by the developed countries to their farmers. So obviously then, which one are we looking at? Which one, is better? Are these subsidies, better? And when I say better, how do I define better? So that remains to be defined. Some of these subsidies have been struck down in cases, but not all of them. So some of them are still very much legal. So on the one hand is the fact that the WTO law allows some of these subsidies, and on the other hand is that the WTO law is very much bothered by our public stockholding programs. Now, remember that our public stockholding programs are not at all unilateral, they're not at all extraterritorial, the way Article 20 is. Now, if we were not to use these public stockholding programs, could we make use of Article 20? So basically, we could just say that Para B talks about human life, Para G talks about exhaustible natural resource, if human life is an exhaustible natural resource. So are we going to say that we want to protect human life, and so we will indulge in public stockholding, even if that involves support to farmers? So that's one question that could be looked at under Article 20 if we are being told that do not use public stockholding programs. Okay, obviously, I think it's more important to tell the developed countries to stop giving subsidies because the amount of subsidies is much higher than the amount of our public stockholding programs. Then let's go on to labor environmental protection. I think a lot of my colleagues talked about it already. This can be used under A, B, and G. So Somebody could say, for example, the EU could say, I will not import your carpets made by child labor because it's a question of public morals in my territory. It repulses the public morals of my citizens the way they did so in EC seals. Or they could just use clause B for it, or even G, because they feel that the life of children is an inexhaustible natural resource, whatever. In any case, so that is also a possibility. Now, if that is going to be used, then we must keep in mind the criteria that appellate body has laid down in US shrimps. One, it says openly, and we know it, that unilateralism is a part of Article 20. So that is something which we will not be able to counter in case we are subject to any restrictions under A, B, and G. Extraterritoriality, the appellate body said, I do not decide on the question, but actually decided on it. So we all know that extraterritorial measures are included in Article 20, whether or not the appellate body decides to rule on that issue. So that's one thing. So we could use these clauses for labor environmental protection. It doesn't always have to be in unidirectional. It's not like the developed country always has to ban the products of the developing countries and say, you're violating labor rights, you're violating environmental protection, and so I ban the import of your products. It could be the other way around as well. So there are possibilities. Then let's look at the TRIPS. Now I'm leaving Article 20. I'm coming to TRIPS. So TRIPS, as we all know, allowed compulsory licensing, but Article 31F clearly said that this is predominantly for domestic use. Now, obviously, this was not very useful for the countries with no manufacturing capacity. Please note that Article 31F is an exception, and an exception to that exception was required in the form of the amendment of TRIPS, that is 31bis, which says that such countries that have no manufacturing capacity can import from a country that does have manufacturing capacity. Right? So basically, and again, if a country is to import these goods, then basically, again, this will not involve any kind of extraterritorial or unilateral jurisdiction against another country. So that was, it's good, that exception. But again, you see that TRIPS, like the GATT, also makes use of exceptions to protect human rights in this case. So basically, if this amendment had not been made, and the amendment was made with a great lot of effort, and then it took a lot of time for it to come into force to receive the adequate number of ratifications. So if this amendment was absent, then could the countries that have no manufacturing capacity made use of Article 20B and G? Could they have said that, well, I am going to import these medicines from, let's say, a country like India or Brazil that does have manufacturing capacity under Clause B of Article 20, because I need to protect my human life, and irrespective of the amendment of TRIPS, which happened much later. So that's one thing. If they do that, well, again, it would not be unilateral, it would not be extraterritorial. So that would have been a good thing. But they could not do so because Article 20 only applies to exceptions to the GATT and not to any other agreement. So then the other thing you could look at is Article 27, Paras 2 of TRIPS, but that just says that don't grant a patent for reasons like ordre public. Do I translate it as to public order? Because the two concepts mean two different things in English and French. So the point is that a country could say, well, in my territory, my people dying of these diseases is really a problem of ordre public, and therefore, because there's no amendment in TRIPS, I'm going to use Article 20. So, it could do so. Or it could just say, well, under Article 27, Para 2, I'm allowed not to patent. So either I just don't patent. So there are these possibilities, but theoretical, very difficult to use, because if Article 27.2 had any substance, we would not need an amendment. We would not need 31F, and we would not need an amendment. So that was one thing. Then let's look at another point here is the enabling clause. Now in the enabling clause, so I'm moving away from Article 20 now. So again, in the enabling clause, you know that the donor countries impose a lot of conditionalities on the recipient countries. Now these conditionalities may be imposed under Para 3C or without Para 3C of the enabling clause. If imposed under Para 3C, then is the donor country required to ensure that these conditionalities respect the sustainable development and human rights needs of the importing country, of the recipient country? So, and if so, then can we say that the WTO law is a very good law, that it allows protection of human rights and sustainable development? Well, even if we say it is good, well, good or bad, that's something subjective. If we say it's good, remember it's in an exception, because the enabling clause is an exception that allows discretionary GSP schemes. And these schemes are not obliged to have conditionalities. So it's going to be very difficult to say that, let's attribute this goodness or badness to the WTO law. Okay, now if the WTO law is so amorphous and ambiguous, and we have no answers to these questions. So then let's look at the VCLT. Now, if you look at the VCLT, there's two articles I'm looking at, 31.3c and Article 53. Now, 31.3c basically says that a WTO judge can apply non-WTO law, that is Human Rights and Sustainable Development Treaties, if the WTO disputing party is a party to it. So which means that the non-WTO law can serve as a defense in case of WTO law violation. So that's possible thanks to 31.3c. The other prevailing view, but which has been controverted, is that in any case these treaties would prevail over WTO law because they include integral rights, whereas WTO law just includes reciprocal rights. So you could deviate from WTO law as long as it doesn't cause nullification, impairment, doesn't cause any form of harm to other parties. So this is again the moralistic approach which my colleague James took, that human rights, well, he says human rights and trade are equal. This approach basically says human rights and sustainable development would prevail or trump over trade law. Well, the word trump seems a bit inappropriate here, but in any case, so so that's Article 31.3c. So again, again we have a situation where if we apply 31.3c, things might work, but if we apply the integral rights versus reciprocal rights approach, things may not work because, as you know, international law is fragmented. So if that is the case, let's look at Article 53 that talks of Hughes-Kogan's norms. So could we do something like classifying human rights and sustainable development as Hughes-Kogan's norms? And if that is the case, then are we going to say that the WTO agreement before the TRIPS amendment was void by virtue of Article 53 of the VCLT because it allowed the death of suffering people? So till the time we got the amendment, are we going to say the entire WTO treaty was void? If we say that human rights and sustainable development are Hughes-Kogan's norms. Actually, when you look at examples of Hughes-Kogan's norms, some of them overlap with human rights. So you've got examples like genocide, so you shouldn't be indulging in genocide, but then genocide is all right to life. So are we going to then use Article 53 against the WTO law? Well, if we use it now, it's still okay, but if we use it before the amendment, it would have been really problematic. Okay, so you've got all these questions, and now let's look at some answers. So, so these questions that are raised were all without answers. So I said that, we can look at the WTO as being pro-human rights or pro-sustainable development, or anti-human rights and anti-sustainable development. Depends on how you look at it. You could say, yes, it's great because at least it has exceptions. It's a trade organization, but it allows exceptions for these issues, and so it's a great organization. Or you could say that, it only incorporates these issues in the form of exceptions, so it's not a great organization, but that's not what I'm looking at. The next thing which we're going to look at is fragmented international law. So are we going to say that, there's no solution to the problem unless and until you find a central overarching authority in international law? Well, that's not going to happen in the near future. Okay, so then the third thing that I'm looking at, and that's where I think I find my answers, is are we going to blame the WTO members for this? Well, I think we will have to. We don't have a choice because they are the legislators. So if they have come up with this law where we are raising questions and we are unable to find answers and we are trying to find connections between this law and the VCLT, these members should actually be more active. So I think that there's some ways of making them more active. Well, one is just make more use of the existing exceptions. That is one. So that's the simplest one. The second one is a bit more difficult. Ask for more relaxation of the interpretation of these exceptions, especially the necessity test, which may be difficult to fulfill currently. And the third one actually goes a bit further and says that, the WTO members could perhaps ask for protection of human rights and sustainable development, but not as exceptions. So basically, perhaps, have a provision which may say that these would prevail if there's a case of conflict with trade law, but that sounds very difficult, because it's going to be difficult to have consensus. So, of course, questions have been raised as to how useful is the consensus rule in the WTO law, but it's obviously better to have consensus than to have a Security Council type of feature. But because of that consensus rule, it's going to be difficult to implement, especially the last suggestion. But still, at least the first two suggestions perhaps members could look at. Thank you.
Thank you, Pallavi. I think